Welcome to the Estates Made Simple podcast with Jenna Carvello and Gordon Vanderleek. We are on a mission to simplify the world of estate administration, helping executors gain the knowledge required to manage an estate. Please note, the following is for informational purposes only and is not to be considered legal, tax, or financial advice. We recommend you seek individualized advice for your unique situation with qualified professionals.
Welcome to the Estates Made Simple podcast. Today, we are going to bring you a bit of a treat. We're going to share one of Canada's most famous estates and share perhaps how we would administer it if we were in charge. This is something that Gordon and I were talking about beforehand and comes with a lot of issues, but also a lot of fun. So let's get into it. This estate is from the late Charles Vance Miller, who passed away in the 1920s in Toronto. He was a well-known lawyer, and he was known for doing a great job for his clients, but also for the jokes that he decided to make during life and in death. And so in his will, it became famous after his passing, but his will, he left a number of gifts to unusual recipients. One, he left a joint tenancy in a home to individuals that hated each other on the condition that they lived there together. He left Catholic-based stock to Protestant ministers. And he left people who did not enjoy racing or didn't support gambling he left them his racing stock. So he wanted to really challenge people and get them out of their comfort zone. What he was perhaps most famous for was what he left the residual clause in his will to. So all of the leftover funds after these gifts had been made, after all debts are paid, expenses are paid, was to the woman in the Toronto area who could have the most children in 10 years following his death. As you can imagine, that created a big race to have kids, and what actually became known as the Great Stork Derby. And there is a movie named after him and the Great Stork Derby. So we encourage you to look it up, but we wanted to talk about the complexities of this estate and also highlight how interesting it would be to administer it. Because one, estates can be very unique to the individual, and I think that gives us clues on how we can structure our own estate to do exactly the way we want it to happen. But two, just dealing with these complexities does unravel a lot of other issues and just the stress that it could cause in trying to ascertain who actually are the beneficiaries of the estate. Gord, if you were the executor dealing with this will, what are the first few major things that you would do to start the administration?
Yeah, thanks, Jenna, and appreciate you bringing this to our attention and having it on the outline for our discussion today. And I guess a preliminary comment before I answer your question would be, it would take a lawyer to draft a will that had these types of clauses with a big smirk on his face going, this is going to be fun in my estate. I hope he had proper disclosure to the executor going, this is what you're getting yourself into. And we've talked in other podcasts about getting the consent of the executor. I don't know if that happened in this case or not. But I'm smiling going, maybe if he was a litigator, he goes, he always enjoyed getting reported decisions and being listed as the counsel on reported decisions. He goes, this is my final act. I'm going to have a reported decision, but it's about me and my estate and the will that I drafted. So certainly wouldn't encourage generally the drafting of a will with so much complexity that you're inevitably inviting litigation and or the having to reach out to the court to figure out how to administer the estate. That just increased costs, but he may have said, hey, I don't have spouses and kids to leave the money to, so I'm going to have some fun. Yeah, it's a good story and an interesting one to delve into. To your question about what are first steps, I think the first thing that comes to mind is about securing the assets, right? So he talks, there are specific gifts that you mentioned in the will. So there would be, if he had a vacation home, I think the facts are there was a vacation home in another country. So you'd have to figure, okay, let's secure that. Is it under lock and key? Is it properly insured? If you have shares in a particular, I think one of the facts was he has shares in a brewery. Where is that share certificate? And is that in a place of safekeeping? What are the details of that? So just in today's world, you have to go through an application for a grant of probate to validate the will and receive the authority to begin to administer the estate. So you want to adequately describe them, value them, and protect them as an initial first step. The other part of it, which beyond the bizarre facts of his case is applicable in every estate, would be you got to figure out who the beneficiaries are. So if there are, I think, a reference to anti-horse racing advocates, right? And he left them shares or his interest in the jockey club as an appropriate, obviously he felt was an interesting gift. So we got to find these people and get the appropriate information. And because you have to list the beneficiaries, they're entitled to notice. And presumably there was even some sort of notice requirement in 1920 when this would have gone through the probate process that these individuals would have to receive notice that they were mentioned in the will and here's your entitlement. So you need to take that particular step. The interesting thing, I guess, thirdly, with regard to this estate would be trying to determine who the residual beneficiaries are, because normally the beneficiary is named. But what we have here, I think, is an example of a class of beneficiaries. There's not named individuals, but it's a little more complicated, but it kind of akin to saying, I leave money to my nieces and nephews. Okay, who are the nieces and nephews as of the date of death? That could be, we've seen those types of clauses. But in this case, it would be to women, because the qualifying criteria would be resident in the city of Toronto. So we got to figure out, okay, what are the boundaries and what is the residency and how do we figure out who these women are? And then with the additional condition in the form of a bit of a contest to say over 10 years, who is the person who has given birth to the most? And again, it probably would only be a lawyer who would create this kind of administrative nightmare, if you will, because he also set a period of 10 years. So then my brain is going, the executor has to keep this estate open for 10 years and cannot be distributed other than the non-residual gifts. But just trying to figure out, presumably you have to advertise, you have to let people know, and there's a period of time in which they may qualify. It's not who had the most children as of the vital statistics record as of the date of death. You could do a search and determine that perhaps based on public records for that municipality. But this is in fact a 10-year contest, or as you refer to it, the Great Stork Derby. I love that name to describe what is going on here. So during the 10 years, what do you have to do by way of advertising and say, by the way, this is out here? Because if you don't, somebody could come back and say, oh, had I known about that, I would have had more children, or I might have been able to qualify, or I could have been part of that class of beneficiaries. So that would be certainly something to wrap your head around. Not a clear and obvious answer as to how to have that happen, but you'd have to struggle with that because that's the assignment that's been given. I guess lastly, you might, in the era of 1920, and you shared information when we were talking before that this estate did get wrapped up. So there was perhaps not a challenge to this, but I could see maybe in a different era, different societal standards, that in 2025, does this kind of clause get attacked for being against public policy? And if it fails because it's against public policy to give financial incentives for people to become pregnant and have a successful pregnancy, does the residue fall on intestacy? Which it would on the face of it if that was an invalid clause. So with that being said, those who would benefit on intestacy, his nearest next of kin, could potentially bring a challenge, or do we need some court order to confirm that in fact we're doing it this way and this is all legitimate and protects the executor from making the appropriate decisions? Just the novelty of it would almost inevitably, in my thinking, say you need a court order, right? Because this is so out of the ordinary. How do you otherwise protect yourself if somebody's going to come along and say, hey, I should have received part of that. And are you just inviting getting sued for making the wrong decision? So the interpretation of the court, I think in today's day and age would be, does it offend public policy? Is it a legally valid distribution of the residue of the estate? And who's affected if it's not? Who needs notice of that? And just having confirmation that it's valid, and then you proceed to actually properly implement it and figure out how to do that, and how much advertising do you have to do to ensure people are adequately informed with regard to this contest, if you will.
Funny you mentioned that he did have some distant relatives. He didn't have any children of his own, but he had some distant relatives that tried to challenge the will. I don't know on what grounds, but they were unsuccessful in that. So as you mentioned, maybe it would be different today, and it would be interesting. Maybe, Gord, you want to structure your estate in this way, but it would be interesting to see what would happen if this was a will that was administered in today's day and age.
Indeed.
So if I was an executor, some things I would think about too is setting up a mechanism to verify the candidates, because I could imagine there's probably several individuals who try to ascertain that they had enough children or that all of these children were theirs, but really to verify and keep record of all the individuals who were applying for the residue would be an important consideration. I would also think about investing the funds over those 10 years, because if it wasn't properly invested and didn't earn perhaps a sufficient return, or on the flip side, the capital decreased over time, that could also put me at risk as an executor, that I wasn't managing the funds properly to maximize the value of the estate. What would my fee be to administer this estate? That would be a lot of work to do over the 10-year period. So I'd make sure I'd be tracking my time, my tasks, and also the liability associated, so that at the end of the 10-year, I can apply to the court and say, this is a fee I'd like to charge before the residue is distributed to the individuals.
The other thing would be, if you had to wait 10 years to be remunerated for all the work you're doing over the 10 years, would an application for some interim compensation be appropriate? Because most estates are not open 10 years. I think that's a really important consideration, both the investing and appropriate compensation. One would have hoped that he may have addressed that in the drafting of it and maybe provided some guidance. So there's authorization for pre-taking, but we have certainly set another podcast. The starting point would be, if it was Alberta in 2025, that pre-take your compensation. It's at the end, once you're done your responsibilities, but that's a long time to wait. So maybe an application for the court to approve that in advance would be appropriate. Otherwise, almost a bit of a hardship if one has to wait 10 years to get properly reimbursed the responsibilities you've taken on and the time you've expended.
Absolutely. I know everyone's probably wondering what actually happened in this estate, so we'll share the outcome. In the end, there were 4 women who tied for first place, each having 9 children over that 10-year period. So in today's dollars, they received the equivalent of about $2 million each, which Gord and I were talking about probably is not enough to raise those 9 children over the course of 18 years. But
I'm not sure that's a positive, but yeah, looking at it from the perspective of the kids going, I came into this world under those circumstances and I was the result of the Great Stork Derby. There may be some emotional trauma associated with that has to be paid for from that. But interesting that there's no shortage of interesting cases in estate law. And there's been lots for us to talk about over these prior episodes, interesting cases. And I appreciate you bringing this one to our attention, because there are some teaching points in there, in as much as we can have a smile on our face and chuckle a little bit at some of the unique fact situations. I appreciate some of the teaching points we've been able to make regarding the administration of the estate. Everyone is different. You need to look at the circumstances of each case and make responsible decisions. And where there's uncertainty associated with what you need to do next, ultimately the courts may be there to provide some guidance, but you have to make some decisions and then protect yourself as best you can in that situation. But yeah, interesting story that the census takers in Toronto in the 1920s, maybe they saw there was an increase over this 10 years in the number of births giving rise to this. So fascinating case. And thank you for bringing it to our attention. As always, we appreciate you taking the time to listen to us chat and be part of this podcast or to watch our YouTube channel. So we're delighted that you've spent the time. And as always, reach out to us if there's any questions, subscribe so you don't miss any future episodes like this. And we're always open to suggestions or comments about other items you may want to talk about. So with that, we'll thank you, Jenna, for another great conversation on the podcast. And thanks to our listeners for listening.